Representative Brown,
Present.
Representative Heft,
Here.
Representative Johnson,
Here.
Representative Locke,
Present.
Representative Lucas, Representative Webb,
Here.
Representative Weber,
Excused.
Representative Yin,
Here.
Chairman Knapp.
Excused.
Mr. Vice Chairman, you have a quorum.
Excuse me? Okay. All right. Thank you, everybody, for being here today, and we won't waste a lot of time with decorum and that kind of thing. Everybody knows the rules probably who's in here, and we do appreciate that. What we're going to continue on today was we're going to kind of continue the discussion on Senate File 82, which was duties of registered agent and amendments. We had this, we kind of got halfway into the public testimony part of this. And so we're not going to spend an enormous amount of time on this now, but we did want to give people who did not have an opportunity to testify before on this bill as well. So I guess what I would do is, for now, are there any new people who did not get a chance to testify in the last meeting? And if there are any of you in the room, if you'd please come up and we'd have an opportunity for you to testify. Thank you so much. And for those of you who are here and didn't get a chance to testify, please fill up the seats. Do not be shy. Let's get them filled up and get it rolling. Very good. And please, if you're planning to testify, don't hesitate to fill the seat while someone else is talking. That's completely fine. And thank you. Please proceed.
No, Mr. Chairman, thank you. My name's Kristen Lee, and I might be out of order because my witness is on Zoom, is Mr. Titus Gore, who's the president of the Trust Association. And I don't want to.
Okay.
Is that okay?
So he's on Zoom?
Yes, sir.
Okay. Well, then let's do this. Let's kind of hold you to the end of public testimony. Would that work for you?
Just
Perfect.
Thank
Others who want in the room who want to speak to this bill, please. Good morning, sir. Please introduce yourself and then let's and proceed.
Hi, my name is David Kerr. I'm CEO of Cowrie, which is an advisory practice that works on compliant domestic structuring options for U.S. companies. And we prepare financial statements for the Wyoming Duna projects that have come through as a result of your law. I live up the street. And in the time that I've lived here for the past 2 years, we've put more than $3 billion inside of the U.S. reporting scheme for tax reporting of entities, and we've paid more than $20 million of federal taxes for our clients, or with our clients. And within that space, which is not exactly the easiest compliance space to operate under, we've striven to be the example for what the White House highlights as bringing digital assets home to the U.S. So we operate in a very similar field in a very hard to comply with manner, very transparently, very openly, as kind of the way we conduct our business. I'm here today to speak about SF 82, where the harm that's being discussed in testimony, the way people's addresses are being stolen, the way that's becoming clear to them when they get notices in the mail of the fraud that's occurring, it's a cancer across the United States. The reality is, of the GDP for the entire world, 5% of it at any given moment is illicit finance. That estimate's supported by the US government, it's supported by the United Nations. Inside the United States, the IRS estimates that every 5 years, $11.4 billion of fraud related to stolen EINs is perpetuated in the United States. A huge component of that is being able to utilize RAs as one of the steps along the road to perpetuate those other crimes. No one's filing fraudulent RAs for the purpose of that being the crime. It's to elicit other action. It's the step along the way. I'm hugely supportive of robust legislation that looks at where Wyoming's at on privacy, where every US state is at on privacy, and finding a balance between what information must be collected, and how we can go about solving this, how we can go about preventing this. The bill is drafted for SF 82 doesn't do that. And I know it's getting credited as a start, and we have to start somewhere. And I've heard the testimony that people need to go back to their constituents who have been harmed by this and telling them they're doing something. As designed, this bill doesn't do anything. It adds no enforcement provisions that already existed. It provides no robust tests for any other activity being caught. And it places the registered agents in a very unenviable situation of possessing financial information that other people are going to want. It's been highlighted that it's better to give it to the RA than it is to the federal and the state government. But this law allows it to go to the state government under the compelling statutes. What it also does is it forces the RA to hold information that we all know people want. Ownership information of companies is valuable information. And they will be the epicenter of lawsuits to get that information. The Secretary of State's office being able to compel it from them doesn't exclude anyone else from coming to get it. And I don't think we've thought through the ramifications of what it means to force private citizens and force building to make them into actions of enforcement. If I were in that situation, I would not want to take on the risk as an RA. I know my clients' entities and information. It's part of our process. We work very hard on it, but not every RA has that obligation. And the purpose of the statute is to provide routine enforcement for service of process for lawsuits. We are going into an existing Wyoming statute that functions for that purpose, and we're trying to add enforcement and investigative provisions that do not work. So while I applaud the effort, the interest, and do think that we need to make serious changes, this law as designed is not the way to do it. Thank you.
Thank you. Questions? And sorry, your last name, sir, I didn't.
That's Kerr, K-E-R.
Okay. Thank you, Mr. Kerr. I thought I wrote it down. I wasn't sure I got it right, but okay, very good. Any questions for Mr. Kerr? Very good. Thank you so much for bringing that to our attention. And let me just let everybody know, we're going to kind of keep it pretty tight. We're going to try to stay to that 3 minutes, maybe a little over, but if we can keep it tight, I'd like to do that. We have to move ahead on this little tight up timeline, but thank you. Please, sir.
Mr. Chairman and committee members, my name is Tom Long, and I'm an attorney here in Cheyenne. I founded a law firm that now has 58 employees, 28 lawyers, I think, at last count. I am now of counsel to the firm, and I am trying to retire.
Can you pull the mic a little closer?
I'm
sir?
sorry.
We cannot really hear you well.
Okay, I'm suffering from a bit of a cold I caught on an airplane, I think. Caution to all of you about flying. So I am an attorney in Cheyenne. I founded a law firm. We have offices in 6 cities: Evanston, Casper, Cheyenne, Jackson, also Denver, to get even with those Denver firms that kept opening Wyoming offices, and also Park City, Utah, which is very close to Evanston. We have a large area of practice in advising our clients about selection of entities and use of entities for tax planning, business planning, and estate planning, and often are called on to discuss choice of situs. Do they want a Wyoming LLC to be their asset holding company? Do they want Delaware, Nevada, some other jurisdiction that is open and friendly toward business? We do have clients who are fugitives from other states. In fact, we have had one of our attorneys pass the California bar so that we could go hand to hand directly with the California Franchise Tax Board over issues related to Wyoming-based assets. So this is one of our key areas of practice, and I have testified before legislative committees several times, usually about the LLC statutes or the corporate statutes, updating and getting changes made, going back, I hate to say it, 49 years. I think I first testified in 1983, so not that long ago, for 42 years. The one time I had mentioned how it will make a difference to us if a law is not changed, dealt with the Limited Partnership Act, having to do with the structure of the Wyoming law at that time. We, at that time, were forming limited partnerships in Colorado. And Wyoming changed its law, and I think my testimony helped in encouraging that. But we now use Wyoming entities for virtually all of the incidental or ancillary holding entities or ownership entities for our clients in their business and estate planning matters. What we are concerned about with this bill is it now requires disclosure of membership information that often we as attorneys don't even get, let alone the registered agents. We as attorneys would have an attorney-client privilege. They don't. Under this bill, the Secretary of State can demand to inspect the records of the registered agent. I believe the bill said if it's appropriate in the eyes of the Secretary of State. I'm sure we are going to have some clients who aren't going to like that, especially if they aren't even telling the lawyers about it. And so I think what is going to happen in Delaware, which is one of the...
So, Mr. Long, if you can kind of.
I'll wrap it up right now.
Wrap it up, please.
Okay, I
quickly,
just
since
wanted
we're-
to point out, Delaware doesn't do this. Nevada doesn't do this. South Dakota doesn't do this. Those are the jurisdictions that we are usually debating on going to, and I think they are going to win the debate if this bill passes. Thank you, Mr.
Thanks, sir.
Chairman.
Any questions? Thank you, Mr. Long. Appreciate your support here. And do we have anyone else in the room who wants to speak to this? And I know Mr. Secretary had asked for a couple minutes, but we'll get through some public, if that's acceptable, or would you like, Mr. Secretary, if you'd like to take, you wanted a couple minutes, if you'd like to speak. You can do that now, if you'd like. Welcome, Mr. Secretary, and thank you, please.
Well, thank you, Mr. Chairman. And again, I want to make sure with the first part of the hearing being on Friday that, we talk about some of the issues here and it's in front of the committee at the time of consideration of the bill. We've really taken on fraud in the Wyoming Secretary of State's office, but we're limited in what we can do. We can dissolve entities when there are fraudulent information in the filings that are received with our office. Well, when we have an entity that hasn't lied on those forms, but you have fraud that they're committing against individuals, oftentimes Wyomingites, there is nothing under current Wyoming state law that we can do. And so I really think that this is a tool and something that needs to be discussed. I think it should be moved forward. I'm supportive of that. And I just want to reiterate that aspect to it. I mean, I am troubled over in the Senate where, there were a lot of people that said, well, when I was listening to the debate, a lot of members said that basically expressed opposition to the bill, but said that they were going to vote aye just to keep it going. And I think there needs to be conviction behind this. And I certainly have conviction behind attacking fraud. And I think this is one of the tools to get us closer there. So thank you very much. I just wanted to reiterate that I'm supportive of this. So thank you.
Thank you, Mr. Secretary. Any questions for Secretary of State? Thank you so much. We will do, let's see where we're at here. I don't want to burn too much of our time and make sure we have sufficient time to work the other bill. Let's do this. Mr. Pope, if you're okay, I think what we'll do is we'll try to go through. We've got a handful of people online. So let's go ahead and do that and make sure we take this opportunity to do that, to make sure we include everybody who we sort of cut short last time. Yes, ma'am, please
Yeah,
proceed.
thank you, Mr. Chairman. My name is Kristen Lee, and I'm a lobbyist for the Wyoming Trust Association. The president of the Trust Association this year is Mr. Titus Gore, and he will testify on behalf of the Trust Association, and he's online joining us today.
Very good. And Titus, and what was his last name?
Goare. Gore.
Gore. Okay. All right. Is he online?
Mr. Chairman, Mr. Gore has been promoted to panelist and can feel free to share, open his camera. Thank you.
All right. All right, Mr. Gore, please proceed. Please introduce yourself and proceed.
Mr. Chairman, my name is Titus Gore, and I'm the president of the Wyoming Trust Association. We're an association made up of state charter trust companies, CPAs, and law firms. The Wyoming Trust Association is committed to supporting efforts that ensure Wyoming business entities are used for lawful purposes. We also believe it's important to empower the Secretary of State and law enforcement to identify and investigate potential fraudulent or criminal activity when there is a reasonable basis. Thoughtful, appropriately scaled oversight and regulation help Wyoming maintain its reputation as a credible and robust jurisdiction for trust, estate, and business planning. At this time, the WTA neither supports nor opposes the bill. However, we do have several considerations I'd like to share, with the hope that this bill will be referred for further study during the interim. Before discussing our considerations, I'd like to briefly explain why the Wyoming Trust Association is testifying on this bill. The relationship between trusts and registered agents arise because LLCs and other entities may be placed into trusts. In such arrangements, the trust is the owner and member of record of an LLC or similar entity, but the entity itself and not the trust is the party registered with the state and required to maintain a registered agent. The use of an entity like an LLC, owned in whole or in part by a trust, is a long-established and common ownership structure employed by attorneys in all top trust jurisdictions and across the U.S. The bill as drafted would be a huge policy change in Wyoming and would certainly cause people to move their LLCs and trusts to a state where information on beneficial owners is maintained by banks and trust companies rather than by registered agents. Now, as to our considerations, first, we believe more time is needed to ensure that exceptions addressed in Section D of the bill are appropriate. For example, entities that are already subject to state or federal regulatory oversight should be exempt from this requirement, since information about owners, management, and operations is already maintained and available for examination elsewhere. In our industry, the Wyoming Division of Banking conducts thorough investigations and due diligence on owners of Wyoming banks and supervised trust companies, including background checks, fingerprinting, and ongoing examinations. Furthermore, entities owned or managed by regulated institutions should be exempt for the same reasons. There is already a functional federal or state regulator that regularly supervises and examines for compliance with applicable law. Regulatory oversight also extends to compliance with Anti-Money Laundering and Bank Secrecy Act requirements in some cases. Additionally, Wyoming entities that use state and federally regulated banking services are subject to AML and BSA requirements. We also believe exemptions should apply to professionals like lawyers and CPAs.
Mr. Gore?
Yes.
If you could tighten it up a bit.
Yeah, sure. Yes,
kind of have to
absolutely.
get to
Sorry,
the
Mr. Chairman.
conclusion here. We need to move ahead.
Absolutely. Well, Mr. Chairman, in summation, we think that this bill deserves further study and collaboration. In the spirit of measure twice and cut once, our ask is that we step back to thoughtfully investigate and understand the effects of this bill on the entire Wyoming industry.
Thank you, Mr.
Thank
Gore.
you for
Any
your
questions?
time.
Thank you. Any questions for Mr. Gore? And one thing I failed to ask, the folks who've spoken today, many of you have got proposed amendments and recommendations. I would ask, at the risk of bombarding our emails that have already been bombarded, if you would please forward those to the committee. I would like to see those because I think it's something we just want to make sure we have included. But Mr. Gore, that includes your more detailed recommendations. We would love to see those. Thank you.
Thank you, Mr. Chairman.
All right. Thank you so much. All right. Who else? We have at least two more online, I believe. Yes. Fantastic. Thank you. Let's do that.
Mr. Chairman, we have Pia Angelicus, who's raised their hand, and then Graham Norris, who is also registered to testify
Very
on this bill.
Good. Okay. Let's move on to Miss Angelicus. Technology never works as good as you hope it did, so, yeah. It's only 2026 now, so.
I think I may have been made a panelist rather than Ms. Angelica.
Ah. Is this,
I'm Mr. Norris.
Mr.
My
Norris?
feelings won't be hurt if you
Assume?
skip over to her.
Well, let's go ahead. Since he's online, let's press if that's acceptable. Is that all right? Very good, sir. Please proceed.
Thank you, Mr. Chairman. My name is Graham Norris. I am General Counsel for Wyoming Corporate Services, who is one of the registered agents here in Cheyenne with 12,000 plus clients. And most of the things that I would have said have already been mentioned by Mr. Kaufman on Friday and Mr. Long and Mr. Gore today. Let me just add one or two things and then you can move on. Wyoming law currently presumes that ownership comes after formation. Generally, the formation process is the filing of the articles, and the establishment of who the owners are takes place as ministerial acts at some point after that. The operating agreement is signed, or the newly elected board issues shares. That's not a hard and fast rule, as limited liability partnerships provide some partnership information, but by and large, there are a lot of entities that will not have that formation, that membership or ownership information when the company is being formed. And the registered agent isn't even involved in that activity after the formation of the company. The point was made earlier, what happens, I think Mr. Gore made the point, what happens if the owner is a trust? What happens if the owner is a corporation? Secretary Gray referred to the collection of information as beneficial ownership information, but a close reading of the proposed amendment suggests that it's not beneficial owner information that's being collected, but just regular legal ownership information. It's trying to do what the Federal Corporate Transparency Act took years to figure out and still didn't bat a perfect score. It may be worthwhile to consider what ownership information we're talking about, and not just say owners, throw it out to the throw it against the wall and see what sticks. So as a possible solution, the federal government does in fact have a database of beneficial owners that they've put a lot of time and effort into creating. And while we may not like the concept of the Corporate Transparency Act, that's what was created to solve the very problem that was suggested as the need for this amendment. So the goal of combating fraud committed through the use of Wyoming entities is absolutely commendable. But we already have many of the tools we need. Other tools such as FinCEN's beneficial owner report may be more effective and helpful. But there are certainly enough issues and concerns that should be addressed here that it makes more sense not to enact this legislation at this time, but instead put some careful thought and consideration into some of these issues so that we don't end up combating fraud by simply making Wyoming an unappealing place to do business for everyone. I think that Wyoming is an excellent place to do business, and I think that there are solutions here that will serve both the desire for confidentiality that investors have, as well as the need for enforcement tools that the state requires. That's all I have. Thank you very much.
Thank you, Mr. Norris. Appreciate you joining in. Any questions? Very good. Okay. Thank you so much, sir. And same goes to you. Any specific things you have that you are willing to send to the committee, specific thoughts, they would be always helpful. Thank you.
Thank you, sir.
All right. Very good. So, Miss Angelicus, let me get that right. Okay. Please proceed. And we're trying to keep it to 3-ish minutes. So we'd appreciate easy for me to say. Use staying as close to that as we can. Thank you. And please proceed. Introduce yourself.
All right,
you-
hopefully you can hear me now.
Yes.
Well, good afternoon, Chairman and committee members. My name is Pia Angelakis, and I'm testifying in opposition to Senate File 82 on behalf of NPRRA, which is the National Public Records Research Association, and it's the trade association for registered agents. We submitted written testimony last week that I urge the committee to consider, and we appreciate and understand the desire to act quickly to combat fraud, but we submit that Senate File 82 is not the answer, as it will create more problems while very likely solving none, and most certainly will result in not only a drop in new formations, but an increase in existing Wyoming businesses redomesticating to other states to protect their privacy. And PRRA strongly supports further study of this issue to strike a balance between Wyoming's interest in combating fraud while remaining a business-friendly state that values and protects the privacy of legitimate businesses. Placing regulatory responsibilities on third-party registered agents adds layers and complexity to an already challenging issue and places an unreasonable burden on registered agents who serve a very limited yet very important role in ensuring that legal process is delivered to the businesses that they represent. And PRRA urges the committee to vote against Senate File 82 and in support of a working group study. Thank you.
Thank you so much. And any questions, Ms. Angelicus? Hopefully I said that right. All right. Thank you so much. And thank you all for your time today. I think what we're going to do, I think maybe we've asked for feedback. I think at this point, Mr. I'll just, if you could just take a minute, at worst case too, I know you had some additional comments because we had kind of started and you'd briefly mentioned some amendments, which I know we've looked at, but I know you wanted just a quick minute, so please proceed.
Thank you, Mr. Chairman. Again, David Pope. I'm a CPA and a chartered global management accountant. I also operate a small registered agency. The amendments, if I'm going to keep this to a minute or less, are designed to create a framework around where we may need to look if this goes to interim. It was also designed for me to conceptualize how I could get to a yes on this bill or a future bill. And it addresses the record keeping requirements right now. 12,000 data points is what I would have to maintain as a small registered agent and make sure they're up to date within 60 days of any change of any of those data points. That's unworkable for me, which is fine if it actually, I believed, would do what it was intended to do. So Amendment 1 deals with that. Amendment 2, I've eliminated the Wyoming home exception for complying with this because I believe that each entity in Wyoming deserves fair and equal treatment under the law. Amendment 3, that gives a safe harbor to registered agents for information that they have had their best efforts in complying with. Amendment 4, it creates a confidentiality obligation for the registered agent, which is something that's missing in current law. And I think that's important if the registered agent is going to have any confidential information or any information, they need that. 5 is gives the Secretary of State additional rulemaking authority. 6 creates a new class of commercial management service providers registration, kind of like the commercial registered agent. If you are the manager of 20, 30 different entities, actually in this more than 10, then there are record keeping requirements you would have to comply with under this. And then 7, authorization for an enforcement division and software purchases within the Secretary of State's office. As a CPA, and when I am looking at and attempting to find fraud, I use analytical procedures in order to do so, to start the process. And I believe, and there is software out there that Delaware and Nevada and other states use to do this. I would love to see our Secretary of State's office have a 3-person enforcement division that uses those techniques and that are educated in those techniques and actually goes after and is able to fight the fraud.
Thank you, Mr. Pope. I appreciate you coming. And question, Representative Lucas. And let's keep it very tight and.
Yes, sir.
moving forward.
Thank you, Mr.
Thank you.
Chairman. Thank you, Mr. Pope. Wow, that's kind of a lot here. Nobody has really spoken to this, so I'm not sure if you're the right person or whether we need Mr. Crossman or Senator Crago or the secretary, but what do you think that this bill, if enacted as is, would do to, first off, the number of filings? And second, what registered agents charge? I'm just curious about what the impact on those two things might be. And I'm offering it to you because you're sitting in the chair right now.
Mr. Pope, please.
Mr. Chairman, thank you. And thank you for the question, Representative Lucas. I can answer the second part of it, and I can use hearsay on behalf of the Secretary of State because he's already discussed this in a Senate hearing, I believe. He can correct me if I'm wrong. He was thinking that could eliminate 20% of our filings, 20% at 60 million a year. That's $12 million minimum, maybe, if I'm an accountant still. And so that's one of the, and I was estimating 12 to 20 million, just as a broad estimation. For me, my registered agency would have to at least double my charges because again, I counted it up, it'd be about 12,000 data points. We'd have to be sending out regular letters reminding of the clients of their obligations. We would have to cover our risk with this. So, we charge, we're about the middle of the industry, about $150 a year to just be the registered agent. And that would probably at least go up to 300.
Thank you, Mr. Pope. All right, very good. So at this point, if there's no other public testimony, we will close public testimony and committee. Representative Lucas.
Thank you, Mr. Chairman. I've been studying this one since it came up on our radar, and I'm concerned that it is far more than we're able to tackle within the short confines of this committee meeting. And I'd really like to spend time on this one during the interim, and let's do a good job on it. Otherwise, I'm not sure that we'll effectively be able to do that.
So is your motion to table for the end? Or what's
Yes,
the motion?
sir. I move that we table this to the interim.
All right. I know this is not debatable, but I don't believe, but Representative.
Mr. Chairman, thank you. It's a quick point of order. We actually can't table it unless we actually have a motion on the floor.
Oh.
So someone has to move it before we table it, or we could just have no motion on it. Either way.
Okay.
What does that mean?
So we have to move it to table it. So we've got to get our procedure right. So let me ask, is there a motion?
To move the bill?
Okay.
Is that what you
Is there
mean?
a second?
Okay.
Okay. Now your motion?
Thank you, Mr. Chairman. I move that we table this topic to the interim session.
Very good. Thank you. And thank you for that procedure. A question, I know this is not a debatable option, but I guess we probably need to proceed, but I assume we can still have some discussion on this. Is that, I would like to have a little discussion on this. At least I'm going to give my opinion on this. Very important bill. A very important process, actually, in my opinion, for us to move forward. And clearly significant amount of work to really get this right and make sure we do a good job, considering the scope of the change, that potential scope of the impact to the state. But more importantly, us getting the fraud issues right and getting the holes patched and bulletproof. So I agree. Again, maybe I'm stepping out of school. If I am, someone calm me down. I know the representative will if I'm out of line because I'm not trying to be, but I think it's important enough that we make this a priority in the interim as we move forward. So it's certainly going to go on our list and be on our team's discussion. And again, I thank the bringer of the bill for bringing this and pushing the issue. And so other discussion, please feel free. Yes.
Thank you, Mr. Chairman. I would like to say that I share some of the concerns with the filings that would take place and like that. I also would like to say that I appreciate the Secretary of State's commitment to battling fraud here in the state. And I really appreciate the work that he's done on this, and I know he will continue to do that work. And I just I would like to thank him for the work he's done on this. So thank you very much, Secretary.
All right. And seeing no others, if you'll please just take roll on the, or I guess I can
Chairman, you
do,
don't
I can
need
do a
to take roll.
voice.
Correct.
Let's all in favor of the motion to table for, say aye. Aye. Opposed? All right. Ayes have it. Thank you so much. And thank you to the bringer of the bill. I really appreciate that. All right. Moving on to the bill that I'm trying to find here, and I will find, I'm sure. There we go. House Bill 40 or Senate File 41. All right. Senator, welcome to the Revenue Committee or to the Corporations Committee. I'm sorry, I'm sort of revenued out, but my bad. Welcome, sir.
Thank you, Mr. Acting Chairman. So I bring you Senate File 41, the portable benefits accounts. We do have an engrossed version as we amended it in the Senate. So just want to make sure if you've got your bill, you're looking at the right one. I'm assuming they passed out the engrossed version to everyone.
We do have it, sir.
Great. All right. So there are approximately in Wyoming 65,000 independent contractor workers. That's what this bill deals with. When we say independent contractor, what we basically mean is that it's a non-W-2 employee, self-employed, responsible for their own taxes, and they generally do not receive traditional benefits. The benefits portion of that independent contractor status is what this bill seeks to address. This bill provides independent contractors with an opportunity to access portable benefits that they can carry from one job to the next job. On the part of the independent contractor, it's entirely voluntary, 100% voluntary. On the part of the employer, it's 100% voluntary. No one's forced into this scenario. It's only if both parties want to engage in portable benefits that they can and will if they choose to engage in it. Walking you through the bill, Mr. Chairman, on page 2, let me get my engrossed version, sorry. On page 2, there's a definition of independent contractor. This is important to note. I won't walk you through exactly what it is unless you ask me about it, but the point that's important to know here is that we're using the Wyoming statutory definition of an independent contractor. That's a definition that's been around for some time, one that's been tried and tested in court. So we're not messing with that definition. We're just using what we traditionally use as independent contractor. Next on the bottom of page 2 is portable benefits account. So what does that mean? The meat of what it means is over on page 3, lines 1 through 4. A portable benefits account can mean health benefits, income replacement insurance, vision and dental insurance, life insurance, or retirement benefits. So these are your traditional benefits that an employer offers to an employee. With a portable benefits scenario, those same benefits are being offered. They're just being offered to independent contractors. What is a portable benefit account provider? The main provider is going to be a financial institution. That's on page 3, middle of the page. But it could be an investment management firm. It could be a technology provider or program manager or anyone else that demonstrates what the bill requires could qualify as a benefits provider. On page 4, tells us that any person can contribute to an independent contractor's benefits account. They may voluntarily contribute funds. As I mentioned in my opening statement, it's completely voluntary. Middle of the page, subsection C is an important provision. Any contribution that's made to a portable benefit account shall not be used as a criterion or factor for determining a person's employment classification. So what that means is just because they have a benefit account and an employer contributes to it, doesn't mean they become a W-2 employee. They're still an independent contractor. That's important to note, that the bill does its best to maintain that separation between, because if you're an independent contractor by choice, you probably don't want to be an employee. So you don't want to engage in any activity that's going to transfer you into that realm of being considered an employee. And this bill seeks to make it really clear. I do have an amendment right here, Mr. Chairman. We didn't catch this on the Senate side, but Workforce Services did bring this up to me. On subsection C, we reference a statute for independent contractor, but there are actually two statutes. So we would need to include that other statute on line 11. It would be or, and then 27-14-102A XXIII. That's the definition I referenced earlier for independent contractor. We would need to include that here. I don't think it's a huge deal if you don't, but it would make the bill a lot more concise and clear if we did that.
And sorry, Senator, can
Yes.
you
Repeat?
please, I'm sorry, I just so we get
Yeah,
that.
so on line 11, page 4, after the period, you would insert or, and then this other statute, which is 27-14-102 little a, and then XXIII. And it's
Very good. Thank you, sir.
yeah, it's the statute that's being referenced back on page 2 of the bill. For the definition of independent contractor.
Very good. Thank you.
Subsection D here tells us that a contribution may be, it may come out of the independent contractor's pay, or it may be in addition to the independent contractor's pay. That's to be worked out between the independent contractor and the employer. If it is expressly agreed to in writing between the independent contractor and the employer, and then it is part of whatever their work agreement is. And then bottom of page 5, the independent contractor can opt out of an agreement at any point in time. So they can start receiving the benefits, decide they don't want them, they can opt out. The hiring party, which is the employer in this bill, bottom of page 5, can also opt out, but they must give a 60-day notice to the independent contractor that they're basically terminating the benefits. That's the bill, Mr. Chairman. I would be happy to take any questions.
Thank you, Senator Olson. That was, I really appreciate that. Questions for Senator Olson? Representative Yin.
Mr. Chairman, Senator, good to see you. I'm curious, so independent contractors move a lot more than companies do, right? So what happens when an independent contractor moves states? Will these follow him? Does it depend on if the state has a similar bill passed, et cetera? Walk me through it.
Senator Olson, please.
Mr. Chairman, Representative Yin. So there are only a handful of states that have enacted portable benefit laws, I believe 3 or 4. I can't remember off the top of my head, have to look that up, but it's gonna be a state benefit is what it is gonna amount to, unless there's a federal change or you move into a state that's gonna recognize those portable benefits. So depending on the type of benefit, you may lose access to it. So if it's a vision or a dental, you're probably gonna be basically what they call out of network when you move out to another state. I mean, that can already happen under traditional insurance already. So nothing is really different there. If you had a health savings account type benefit, then you're still going to probably have access to that money and be able to withdraw it. I don't think that would necessarily be an issue. Or if you had like an IRA type benefit, that retirement account, you're going to move from state to state. It's going to exist. You might not have any more contributions to it in the state that doesn't have a portable benefit law, but you wouldn't lose your retirement just because you moved to another state, would be my interpretation of the bill.
Representative Yin, please.
Mr. Chairman, thanks. And just to follow up, if for the 3 states that have it, is it pretty aligned with all 3 states, just to make sure that, you know, if we tell someone you have this portable benefit, it will work if you move to those other states or if you come from those other states as well?
Right. Senator Olson,
Chairman,
please.
thank you.
And Mr. Chairman, that's a really good question. It is aligned primarily with one of those states. I know because that's the state we used to begin the model of this legislation. That's the state of Utah. We modified this bill a lot to make it fit within Wyoming definitions of independent contractor and things like that. So it would definitely model that state, but I can't speak to the other states. I didn't spend a lot of time with their laws.
Other questions for the senator? Representative Lucas, please.
Thank you, Mr. Chairman. Senator, thank you very much for bringing this to us. I'm assuming, and please correct me if I'm wrong, that the contributions on this would be post-tax because there's no provision for pre-tax treatment. Is that correct?
Senator, please.
Mr. Chairman, Representative Lucas, no, I believe the benefit would be a pre-tax benefit. So the way it would work is a lot like an IRA. Your employer doesn't contribute to, except your employer's contributing would be the difference. But with an IRA, you contribute money to your IRA. You then get you report that to the IRS. You get a specific tax form that says this is the amount you've reported, and it can be, if you do a pre-tax IRA contribution, then it reduces your taxable income for that. So it would look a lot like that if you had like a health savings account type account. I believe it would be pre-tax, and if you had a retirement, it could be offered up as both, just like it is now. Most employers offer a pre-tax Roth 401k and a post-tax 401k. So it would depend on the option of the benefits. But so I would back up my statement a little bit by saying it would always be pre-tax. I think it would depend on the type of benefit, but I see it mostly as a pre-tax benefit.
Follow up.
Yes, Representative
So
Lucas.
I'm just envisioning from a tax standpoint, how that would look. So it wouldn't be on a W-2, of course, which health insurance shows up as one of those little deductions on W-2. So there would be some type of reporting then on the employer's part for the amount that was totally contributed during the tax year.
Senator,
Mr. Chairman, yeah, Representative Lucas. That's why I use the IRA example, because in that scenario, it doesn't show up on your W-2. Your employer has no idea that you've contributed to this IRA, but you have a separate tax form that you deal with the IRS. So the IRS knows that you had the deduction. I imagine it would look like that. But in this scenario, you're correct. I think the employer would have to issue, just like it does issue a 1099 for the independent contractor. It might note it on the 1099, or it might issue a separate tax form. That I don't know. It's not really contemplated in the bill. I'm sorry.
One more thing.
Representative Lucas.
Thank you, Mr. Chairman. I hope I don't lose that question that was just in my head there a moment ago. Well, it's gone.
All right.
It probably wasn't that great.
Darn.
Thank you.
So
I talked so long, you lost the question.
Aren't we grateful? Thank you.
Thank you so much. Other questions for the senator? Excellent. Thank you so much. And Senator, if you don't mind not going too far, because I will bring others up, but we might have questions that will always be valuable for you to answer. So, uh-oh, she came back. So
Boy,
you
you're
really
fast.
thought you were going to get away.
Thank you, Mr. Chairman. So Senator, then I'm envisioning this would look something like a health savings account at the bank, kind of how those are set up and handled. I'm wondering how the bankers, if they're all on board with having a new kind of savings account, or is it something they're already used to doing?
Senator, please.
Thank you, Mr. Chairman, Representative Lucas. I think it's possible you might hear from some financial institution representatives today. Hopefully you will. But as we moved this bill through the other chamber, we did not receive any negative testimony from any financial institutions.
Excellent. Thank you. If no other questions, thank you so much, Senator. I really appreciate you presenting this for us. All right, other testimony on this bill? Good afternoon, sir, and welcome.
Hey, thanks, Mr. Chairman. My name is Tyler Lindholm. I'm the State Director for Americans for Prosperity here in Wyoming. And really a big thank you to Senator Olson for carrying this legislation. And something he didn't touch on that I wanted to touch on briefly, there's kind of a divide that exists between part-time employees and full-time employees. And in a lot of cases, the employers of said part-time employees would like to provide those benefits, but it's a huge risk factor of taking them full time because there's a lot of federal regulations that do kick in at that time. This provides that opportunity to kind of bridge that gap where those employers of the part-time employees then at that time can contribute if they so choose. It's completely voluntary. There's no mandates in this legislation. If they choose to contribute towards that employee's health savings or vision, dental, whatever it might be, Mr. Chairman and members of the committee. And that's that personal choice aspect that is so important in our healthcare that is often missed, especially at the federal level. That's why we're on and in support of this legislation. Mr. Chairman and members of the committee, I'll stand for any questions.
Questions for Mr. Lindholm? Yes, Representative Lucas.
Thank you, Mr. Chairman. Mr. Lindholm, welcome. Maybe it got said and it just kind of skipped out along with my question earlier, but what other states are offering this type of benefit?
Mr. Chairman.
Please.
Yeah, thank you, Mr. Chairman. To the representatives, great question. There are 4 other states that currently have it. Mr. Chairman, members of the committee, Utah, Kansas, and I believe I would have to look up the other 2. I apologize. I do know, Mr. Chairman, members of the committee, this legislation, portable benefits, is being ran in at least 12 states right now. So the opportunity at the end of this legislative year across the country greatly expands that opportunity for those portable benefits to be able to follow that individual through their path.
Other questions for Mr. Lindholm? Mr. Lindholm, thank you so much for.
Mr. Chairman, just
Oh, sorry.
briefly.
Sorry, Representative. I didn't mean to-
Mr. Chairman, Mr. Lindholm, thank you. I'm curious on whether, this incentivizes businesses to just have independent contractors instead of having the employee protections that would be granted if a worker was an employee instead of an independent contractor. Do you think that should be the goal, that we have less employees or more independent contractors? Or what do you think the real value of, what do you think the long-term implication of enacting this would be?
Mr. Lindholm.
Yeah, thank you, Mr. Chairman. And to the good representative's question, I think it's a great and a fair question. Does this incentivize moving individuals to a full-time status is essentially it. And I don't believe it does. And here's my reasoning why. And it's not anything fancy or anything like that. Mr. Chairman, members of the committee, I have full-time employees and part-time employees. When I look at our full-time employees, built into that compensation package are all the benefits that go with them. I also make my full-time employees work on weekends. One of them is sitting behind me that just got done working this last weekend. Whereas with our part-time employees, we're really restricted as far as what we can provide and do for those individuals. So really, my motivation is to move them more towards a full-time. Just last year, I was only at 3 full-time employees in the state of Wyoming. Now I'm at 6 full-time employees. We get so much more out of our full-time employees than part-time. It's not a consideration for me on the benefit aspect.
Representative Yin, you okay? Very good. Other questions? Thank you so much. And actually, thank you for that question. That was
Thank you, Mr.
a good
Chairman.
insight that maybe some of us had missed. Very good. Thank you and welcome to corporations. I'll get it right this time.
Mr. Chairman, Shane Schultz on behalf of Wyoming's credit unions. I'm with a law firm here in town, but I help represent them. And I just wanted to let the committee know that in the case of representing one of the financial institutions that kind of is in the definitions that were offered in the Senate side, we think this is a good piece of legislation. We were really happy to work with the sponsor on the Senate side to make some tweaks just to make sure that the definition covered financial institutions, so banks and credit unions and any other financial institution that's within the current statutory definition. And I know that it was referenced in a question by Representative Lucas to see where some financial institutions are in the state. And as we see it, we think there's some opportunity potentially to help serve, in that kind of capacity for the portable benefits depository.
Very good. Any questions for Mr. Schultz? Thank you so much. Oh, other public, any other public comment on the bill? Representative or anybody, please. A question?
Yeah.
Okay. We'll see. Go ahead, Representative.
Thank you for entertaining my question, Mr. Chairman. I'm just curious about further rulemaking, and maybe I missed some language, but because it sounds like there may be something that maybe perhaps isn't yet done or is done, but I'm not.
Olson,
sure.
please. That would-
Yeah, who would be
Good to
authorized to
hear
do
your
further
thoughts on that.
rulemaking?
Great.
Thank you.
Thank you, Mr. Chairman. Great question, Representative Lucas. There is rulemaking. It's a section 2 on page 5. It's the Department of Workforce Services, which does have a representative in the room. So if you had any specific questions for Workforce Services, I'm sure they'd be more than happy to answer those questions.
Thank you so much. And we won't torture anybody to come up if they feel like it's covered. So other people who want to speak on this bill? Departments or representatives or anybody is good. Just making sure, because I have been accused of cutting off public comment too quickly. Very good. Then we will close public. Is there, oh, sorry.
There's no one online, Mr.
Oh,
Chairman.
great. Thank you. Okay, they'll keep me straight here. So seeing none, then we will close public comment. And committee, what's your pleasure on the bill? All right, the bill has been moved and seconded. All right, let's go through the bill real quick. Well, not too real quick, we're fine. And but let's just, any amendments? Let's start with page 1. Page 2. Page 3. Page 4, Representative Yin.
Mr. Chairman, thank you. I would move the amendment that was proposed by the sponsor of adding on line 11 or 27-14-102 Romanet, sorry, A Romanet 23.
Very good. And it is seconded by, so moved by Representative Yin, seconded by Representative Brown. All right, we'll continue to move through. Anything else on 4? Oh, yeah, we need to vote on that amendment. Sorry, discussion on that amendment. Sorry. Discussion? All in favor, say aye. Aye. Opposed? All right. Any other amendments on page 4? Page 5? Or page 6? Seeing none, discussion on the bill. Yes, that's the one we already did. Yes. Any discussion on the bill? All right, question on the bill, please call roll.
Mr. Chairman, this is a roll call vote for Senate File 41. Representative Brown,
Aye.
Representative Heft, Representative Johnson,
Aye.
Representative Locke,
Aye.
Representative Lucas, Representative Webb,
Aye.
Representative Weber,
Excused.
Representative Yin, Chairman Knapp.
Excused.
Mr. Chairman, that is 7 aye, 2 excused.
Very good. Okay, so Senate File 41 has passed House Corporations, and that, I believe, is our agenda for the day. Any other comments, questions from the committee? Seeing none, we'll adjourn, and everyone have a blessed day. Thank you.